thank you all for coming to another Scientist's Warning program. I'm Stuart Scott, one of your hosts. Victoria Hirth is the other host. And we're coming to you live from the Conference of Parties, COP24 in Katowice, Poland. Victoria is Associate Professor of Sustainable Business with the University of Plymouth. And I'm the Executive Director of ScientistsWarning.org and a member of Survival University. And today's guests, we have with us first Dan Galpern, who's an adjunct professor of environmental law with the University of Oregon's Law School. And he is legal advisor to Dr. James Hansen, who is an icon in the field of climate change. And also with us is Sarah Mead, who works with public international law at Leiden University in the Netherlands. And today's program, we're calling Suing the Bad Actors.
Well, let me say a couple words by way of introduction. I think what we want to do here is talk about the potential for climate litigation to address the fundamental predicament in which we find ourselves. Essentially, emissions occur under national jurisdictions, so the nations are responsible. Emissions are the result of our over-reliance on fossil fuels to power our economies. And so major fossil fuel companies that extract and process, refine, sell, market, and bend the politics of nations to ensure that the emissions that ultimately result are unfettered, that they can continue to use the atmosphere as an open sewer. Those major national corporations, I would argue, are also among the bad actors, as you put it, highly responsible parties. And so the question is, can litigation usefully address this predicament?
Yeah.
I think the answer is probably, but in fact, to employ a legal term, the jury is still out, literally and figuratively. Certainly, and perhaps, Sarah, you have a view on this as well, climate litigation cannot take the place of the United Nations process. Do you concur?
Essentially, climate litigation is a way of holding states, in this case, states accountable for the targets and the commitments that they make under the UNFCCC and the Paris Agreement. But also, I think after I go through some of the ways in which states have been held accountable, there's also increasingly action to hold corporations accountable. But I'll take us through some of the cases which are being brought in Europe in particular to hold states to account for their commitments under the climate change framework. So the first case that we have, and which is up on the screen there, is the Urgenda case. And that's a landmark climate change decision, which was brought by Urgenda, which is a citizens-based organization, and almost 900 citizens of the Netherlands to force the Netherlands to increase its global greenhouse gas emissions targets, on the basis that its target of 17% is basically is not going to protect their citizens from the dangers presented by climate change. And so that was the District Court of The Hague agreed with Urgenda, and that was upheld on appeal in the Court of Appeal of The Hague. And that appeal decision was very clear that emissions target of 17% breached the fundamental human rights of Dutch citizens, their right to life, their right to family life, and essentially said that a minimum of 25% was what would be compatible with the European Convention of Human Rights. And so that was a huge success and really led the way, opened the door for a whole wave of further climate litigation brought throughout the world.
It set a precedent, essentially.
It set a huge precedent and was even cited, even though it was only a district court, so the lowest court of The Hague, it was cited in New Zealand in a decision. So it really, it was the first decision that really showed the potential of climate litigation to force more action by states.
But it seems that the story since then is not so straightforward, yeah?
No. So Urgenda is still a high point, but that Court of Appeal decision has also been appealed. So we have to see if it's upheld by the final court in the Netherlands. But there have been other cases. So the next case was a case brought by Nature and Youth in Norway and Greenpeace Nordic against the Norwegian government.
We can see James Hansen there also joining in.
Yeah, so James pops up in quite a few of the photos.
As James happens to be arguably the world's authority on climate change, and he's cited as expert witness in quite a few cases, yes.
Yeah. So in this case, essentially, the plaintiffs argued that some decisions by the Norwegian government for further drilling in the Arctic were inconsistent with their constitutional right to an environment which was conducive to health. And essentially, it was, in my opinion, a very strong claim, because essentially if oil is found in large quantities in the Arctic, that will be burned, and that's inconsistent with Norway's commitments under the Paris Agreement.
And the Constitution.
And the Constitution. However, the court found against the plaintiffs. And what was interesting was that they departed from the more global perspective of Urgenda and argued that the court said emissions of CO2 abroad from oil and gas exported from Norway are irrelevant when assessing whether the decision for the licenses entailed a violation of the Constitution.
So they're pushing it to the burners of the fuel rather than the extractors, and it's interesting to think where that leads.
Yeah.
There's a bit of hypocrisy, if not, say, conflict of interest within Norway, because they are 60% owners of their oil company, Statoil, State Oil, 40% privately owned, and the pension fund for all Norwegians is funded from that oil. But then it's a question of what will fund the retirement of their citizens better, protect the climate or money. You can't eat money.
And how much will providing a happy, healthy retirement cost if they go down that path? Much more.
So there's an inconsistency because Norway was one of the first to sign the Paris Agreement. It's it's globally seen as a really good citizen, a global citizen, but there's a disconnect. And then I wanted just to also point to the fact that it's not just young people that are interested in bringing climate litigation. There's also old people. This is a picture of the Swiss Grannies case, which was a bunch of older women from Switzerland who essentially have argued that, again, a breach of their rights. They're a vulnerable group to changes in the climate, heat waves and so on, and that's yet to be, we don't have a decision on that case yet, but that shows the diversity of people that are interested in holding their their country to account. I'll just finally, because there are quite a few cases that are brought, and on the face of it, they're not successful. But there are, it's a process, it's a journey, but there is one that has been successful, and this is actually perhaps unlikely. This is a Pakistani farmer. This is not him, but a farmer who brought a case in his local court suing the government for failing to comply with essentially its own climate change policies. So it has a host of climate change policies which it has set, no doubt, or hopefully consistent with its international obligations, but it wasn't acting consistently with those obligations, and he argued this is a violation again of my rights, human rights kind of language again, and the court found in favour. And I think this also shows the leadership that you see from some judges. The decision said, the court said, climate change is a defining challenge of our time and has led to dramatic alterations in our planet's climate system. On a legal and constitutional plane, this is a clarion call for the protection of fundamental rights of the citizens of Pakistan, in particular the vulnerable and weak segments of the society who are unable to approach this court.
In a way, it's going to be very interesting as this sort of litigation spreads throughout the world to see to test those countries
Yeah.
and to see
Yeah.
what is the mood and the sense, and where does the power balance, where do they lie?
And we're now seeing some cases being brought to, like in Germany, where we're seeing states even they're not close to meeting their targets that they've set, and that's being challenged now. So we'll see if that's going to be necessary in the Netherlands.
Wonderful, wonderful.
So in this one,
We've got Dan Galpern here in the first row.
This is a case called Juliana versus the United States, and the woman in front is a person who was a youth when it started, and I think she's about 19 or 20 now. That's Kelsey Juliana, and a number of other children plaintiffs shown in a rally in front of the courthouse, and Dr. Hansen, who's a plaintiff serving as the guardian for future generations in that case, claim bring a series of constitutional claims. The right to not to be deprived of life or liberty without due process of law, the right to equal protection under the law, thus the intergenerational aspect of this case. That case is still in the district court, even though it was brought over 2.5 years ago, because the government has been fighting tooth and nail to have it dismissed. It is currently at the Ninth Circuit Court of Appeals, that is the intermediate appellate court in the United States, and we will see if that case is finally allowed to go to trial. But that's a case in which they're seeking as a remedy that the United States have a thoroughgoing plan for emissions reductions to ensure that that country at least will do its due part to try to preserve and restore a viable climate system.
Now, I have several times already in these programs tried to debunk the notion that this is just a Republican-Democrat thing. The control of the fossil fuel industry is pretty thorough in both parties, and Barack Obama had the opportunity to settle that case after Donald Trump was elected, and Obama was in office for a few months more, and Jim Hansen told me personally that he approached Obama saying, settle it while we have the chance, and Obama, through whatever bad advice he got, decided not to.
Well, I can't comment on that because I used to be an attorney in the case, but that is a case that is of significant interest, and we'll see what happens.
I don't mean to put you on the spot, Dan. I know there are restrictions to what you can say.
The next case, and here we switch gears a little bit. The next case is by a Peruvian farmer who lives in a village that is directly underneath a lake that's formed by glacial melt in Peru. And accelerated melting of the glacier induced by global warming threatens his home and that of his village. So he went to Germany and actually filed suit against RWE, which is the largest fossil fuel company, I believe, in Germany. I believe it's number 14 in the world, one of the 90 carbon majors in the world, who, based on a study by Rick Heedy of the Climate Accountability Institute, who are responsible for 2/3 of all emissions when you tally up their
Repeat that, 90 companies, 2/3?
90 companies are responsible for roughly 2/3 of world historical emissions when you account for the production of fossil fuels for which they are responsible. Useful information. In any event, he went to Germany and filed suit against the company, alleging that it should be responsible for present and future damages, at least that share for which they're responsible. And because you can now account for who is responsible for how much fossil fuel production, one can attribute past, present, and likely future damages to a particular company. And so that is the theory on which a number of these tort suits are being laid claim. brought forth in various countries, and so this is one that is being brought in Germany. This is also interesting because it is a extra-national, a person who is not of Germany, but who is arguing that the damages from emissions by that company deriving largely from the burning of fossil fuels in that country, or the production of fossil fuels in that country, that those emissions are causing damages and threaten to cause damages in his country several thousand miles away.
Why did he choose that company specifically? Were they operating very strongly in Peru? Or?
Well, there we'd have to get into questions of choice of law.
Okay,
and
so there was
very technical questions, but the principle here is fairly straightforward, and that is that a person should be able to sue for damages to himself or his country, and sue those who cause or contribute to those damages in their home jurisdictions, because that is where they have access. That's the principal place of business, and so that is what he is doing. Now, it hasn't gone to judgment yet.
Yeah.
In fact, it hasn't even gone to trial. They're now at the stage of still doing discovery and
Discovery is basically getting everybody to testify before they go to court.
Yeah, getting information, detailed information about the defendant's activities, and they're also doing scientific reports. And so they're still tussling over that. But the fact that the judge is allowing this to go forward, at least to this stage, is very promising.
Because when you relate it to what happened in the Norwegian case, you have what you would think would be a much more straightforward case, because you're talking about extraction in Norway and effect on Norwegian people. And now you have a case here of extraction and burning from a company and somebody in a very different country. So it's interesting to see if that goes further.
Yes, although, I would challenge the notion that this is much less straightforward.
Okay.
And the reason is basic physical principles. We know that these fossil fuels are being extracted and developed for a particular purpose. There's only one purpose for their consumption and burning. And we know now who is producing and developing how much of these fossil fuels. And we know then the contribution to increased warming. We know the contribution to sea level rise. We know generally the contribution of each of these so-called bad actors to accelerating climate change. So I regard what they are doing in Germany as not as quite straightforward, actually.
Before we go on, I'd like to note that we're not dealing with an audience either in the room or out in viewerland. We're not trying to instruct them how to proceed. We're trying to incite them to getting angry and getting a lawyer and figuring out how they can sue with these as models.
Definitely. And this is an example, and Victoria, I make this point here as well, of what can be done. That is to say that cases do not need to be brought only in one's own country. They can be brought in other countries to the extent that there would be legal and strategic advantages in doing so in order to hold those bad actors accountable. I think maybe we should go to the next slide.
There we go.
This is a case in which a number of youth and organized and also represented by the organization Justicia in Colombia to try to compel that government to meet its obligations under the Paris Accord, in particular its nationally determined contribution. And in Colombia, the major reason why that jurisdiction is contributing to the problem of global warming is deforestation of the Amazon rainforest and other rainforests. So their specific demand was to halt the deforestation.
Wonderful, wonderful. I hope we get a precedent there,
right,
because we're going to need it in Brazil.
Exactly. And what was termed a tutela. So here is another case in which you have private citizens challenging its government to do the right thing, and they won. I happen to know a little bit about this case directly because Dr. Hansen submitted an amicus brief that was directly cited.
A what brief?
a friend of the court brief that was, thank you, that was directly cited in the Columbia.
I warned them ahead of time. Any legalese, I was going to challenge them.
Now, Columbia then, it's not enough to win a court case. You need to have it implemented, in this case and other cases, by the government. It is being implemented fairly well, I believe, in the Netherlands, subsequent to the Urgenda decision. And they began a process in Colombia under the former government to have all the agencies take testimony, to develop a plan as to how they would transition to an economy that was not based on destruction of the Amazon rainforest. But they had a new election in August, you may be aware. And it was an open question whether the new government would successfully implement the decision and allow provide for the continued development of a plan led by Justicia and its plaintiffs and members throughout the country for a more sustainable method of proceeding economically without destroying the rainforest. And
now notice, excuse me for interrupting, it's always the economics that's the bad guy, if we want to term it a guy. It's always we're trying to save the ecology of the planet because money, the influences of economy, want to destroy it for money.
This is true. And so I'm happy to report that just a few days ago, I learned from Justicia, the representative here at the COP, in fact, that the new government, the center-right government, again ordered its agencies to continue the process to fully implement that decision.
Excellent.
Wonderful.
Yeah.
Precedent. Good.
I say, apparently because they sent the order to me and it's in Spanish and my Spanish is not so good, but they're going to send me a
We'll get you a translator.
But they told me the gist of it, so
Okay,
that's good.
good.
Okay, so the next, so this is a depiction of San Francisco, and on the bottom right you see Exxon, one of the defendants in this case. In fact, there's a number of defendants in these cases. There's a series of cases brought in the United States by cities and counties, and also one state, the state of Rhode Island, but the cities of San Francisco and Oakland, the cities of Santa Cruz, the counties of Marin and Contra Costa County, and San Mateo County, the city of Imperial Beach, and so on, against the carbon majors, at least investor-owned carbon majors. The major fossil fuel companies, as we mentioned before, Victoria, that are responsible for the preponderance of emissions worldwide. For the damages to these jurisdictions that have occurred already and that are likely to occur, specifically or especially from sea level rise, intrusion of salt water into coastal aquifers, the need to build up seawalls, and so on. These are in various stages of development. Some of them are on appeal from a dismissal. Some are on appeal after the judge stated that they can proceed in state court, but then the fossil fuel industries appealed those favorable decisions. And we will see their development. But again, these cases proceed on the theory that these fossil fuel companies, as Stuart, you mentioned before, knew and with full knowledge continued to proceed to accelerate their development of fossil fuel and to bend the political will in their host countries to ensure against any effective regulation or restrictions on their ability to produce, market, and sell these products when they knew that their intended use would accelerate dangerous climate change.
So is this where we get a lot of motivation for denialism? I mean, I know there are lots of analysis as to why people might deny the science, but there's a vested interest to deny if you can say you didn't know.
That's right. And the denial has occurred at the same time that these companies were changing the heights of their oil rigs to account for what they knew was sea level rise to come.
So their actions were belying their knowledge.
That's right. At the same time that they were fortifying their installations, they were funding this climate denialism that is intended to protect their short-term business interests.
So presumably all of that can be proved quite clearly.
And I think that generally it's considered that at the very least, from 1992, when the UNFCCC was, the Framework Convention for Climate Change was signed, that fossil fuel companies were well and truly aware, at the very least from that point, that there were significant damages involved.
So saying you don't believe the science is not good enough in the eyes of the law because you could just say you didn't believe any risk, and therefore how can you be accountable for any decisions of a business? Yeah.
Yeah, and I understand that there have also been, that this is something that will no doubt come up more, but that there are documents that indicate that these companies were well and truly aware.
Okay, well, we'll entertain questions after we close out the session. Thank you very much. I will also include a call to our audience in the cloud and here. We would like to find more translators for our videos because each of the languages we get adds to the audience. Thank you very much. So this has been a Scientist's Warning program with hosts Stuart Scott and Victoria Earth. There's the contact address one more time, and we've been coming to you live from COP24 in Katowice, Poland.